Good afternoon, ladies and gentlemen. Welcome back to the Public Service Commission of South Carolina. We're here in docket number 2021-88E. Let's take roll. President in the hearing room, we have Commissioners Caston, Thomas, Williams, Powers, Vice Chair Belzer, Chairman Williams, and joining us virtually we have Commissioner Urban. Applicant, please call your next witness.
Thank you very much, Mr. Chairman.
Chairman Williams, I apologize. This is Chris Huber for RS. I was wondering, before we got started, if we could raise one preliminary matter.
Yes, sir. Go right ahead.
We wanted to offer, in light of the status of the proceeding, we are willing to stipulate the testimony of our two witnesses offered thus far, our two witnesses provided thus far.
Okay, you want to stipulate the witnesses Morgan and Horry?
Yes, Mr. Chairman.
Okay. Any objection?
Mr. Chairman, this is Mitch Willoughby for Dominion Energy South Carolina. Obviously, this is news to us. It has not been discussed with us in advance. We may have questions that we wish to ask, so I'm not sure that we're prepared to stipulate at this point. But I'm not prepared to say that we're not prepared to stipulate. I just don't know the answer to that. Since this is a surprise suggestion from Mr. Reader.
Mr. Chair, this is John Burns for CC, but I think I'm in a similar position as Mr. Willoughby. I'm not saying we won't agree to that, but I haven't had a chance to talk with co-counsel or expert witnesses about what questions we might need to ask. So I'm afraid I can't commit at this point.
Well, how about we do this? The lawyers take time to talk about it at the end of the day or over the weekend, and we can discuss it Monday. Is that fair, Mr. Huber?
Thank you, Mr. Chairman.
All right.
Mr. Chairman, this is Kate Nixon. I had an additional preliminary matter that I was hoping to raise.
All right.
Our witness, Kenneth Searcy, will be unavailable due to another commitment on Tuesday from 2 o'clock to 4 o'clock in the afternoon. And so we were hoping to ask for protection for him during that time so that he won't have to testify during that period.
Okay, I think we can make that work.
Yeah.
Anything else? All right, Attorney Willoughby.
Thank you, Mr. Chairman. I would call to the stand as our next witness, Mr. Eddie Folsom. Mr. Folsom, I see you're on the screen. If you will stand by, the court reporter will swear you in, and then I'll begin to ask some questions on you.
If you'll raise your right hand, please. Do you solemnly affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Mr. Folsom, I think you may be on mute. I didn't hear your response.
I apologize for that. Yes, I do affirm that.
Thank you.
Perfect. Thank you very much, Mr. Folsom. Good afternoon. And if you would give for the record in the commission and the pardons, please state your full name.
My name is John E. Folsom, Jr.
And by whom are you employed and in what capacity, Mr. Folsom?
I'm employed by Dominion Energy South Carolina as a senior market originator.
Thank you, Mr. Folsom. In connection with this proceeding, did you prepare and cause to be pre-filed a direct testimony consisting of 24 pages?
Yes, I did.
Are there any corrections or changes to be made to the pre-filed direct testimony?
No, I don't have any corrections or changes.
If I asked you the questions that appear in that pre-filed testimony, would your answers today from the witness stand be the same?
Yes, they would.
Thank you very much, Mr. Folsom. Mr. Chairman, we would move into the record the pre-filed direct testimony of Mr. Folsom as if given orally from the stand.
Mr. Folsom's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Thank you very much, Mr. Chairman. Mr. Folsom, Did your testimony also have attached to it 3 exhibits? The first exhibit being 17 pages, the second exhibit being 150 pages, and the third exhibit being 149 pages.
Yes, that's correct.
Are there any corrections or changes to be made to these pre-filed exhibits?
No corrections or changes.
Mr. Chairman, we would move as the next composite hearing exhibit, the 3 exhibits attached to Mr. Folsom's pre-filed direct testimony, being his exhibits designated as his exhibit 1, 2, and 3.
Mr. Holsom's exhibits 1 through 3 will be marked as a composite exhibit and entered into the record as hearing exhibit 4.
Thank you very much, Mr. Chairman. Mr. Folsom, have you prepared a summary of your direct testimony?
Yes, sir.
Please deliver that summary at this time.
Good afternoon, Chairman Williams and members of the commission. My name is Eddie Folsom. I provided direct testimony in this docket on behalf of Dominion Energy South Carolina Incorporated on June 29th, 2021, and I respectfully request to provide the commission with this summary of the same. I am a senior market originator with DESC, and my responsibilities focus on long-term wholesale power business for DESC. Pursuant to Act 62, DESC submitted its Form PPA, Standard Offer, and Notice of Commitment to Sell form, or NOC form, to the Commission for its review and approval. My testimony addresses certain proposed changes to those documents. By way of background, these documents are available to qualifying facilities, or QFs, under PURPA. By way of background, Act 62 is part of South Carolina's implementation of PURPA. At a high level, PURPA requires DESC to buy power from QFs, which are renewable energy generators sized 80 megawatts or less. This mandatory purchase obligation is often called the PURPA put. Although DESC must buy power from these QFs, DESC does not direct their development, meaning they are not always located where they would be most useful on the DESC system. Although the Form PPA and Standard Offer approved by the Commission are the primary ways in which DESC purchases power from these QFs, Act 62 and PURPA also permit bilateral agreements outside of these documents. As for the NOC form, although it is not required by PURPA, the NOC form embodies a PURPA concept called a LEO, or legally enforceable obligation. A LEO is a non-contractual yet binding obligation under PURPA that permits a QF to lock in rates prior to executing a PPA. However, in exchange, the QF must evidence a seriousness of commitment to ensure that DESC can rely on such QF to sell power to it and proceed through development. Other states have interpreted the level of commitment required, and it is clear that a QF must substantially commit itself to sell power to DESC in order to lock in rates via the NOC form. As such, the NOC form requires the QF to demonstrate certain fundamental commitments to development, such as site control, permits and zoning applications, submission of a non-refundable fee, and commitment to a delivery term. These mirror concepts that have been implemented in other states and cited by the FERC as recently as last year as acceptable examples of items that a utility can require a QF to demonstrate prior to establishing a LEO. In this docket, DESC is proposing changes to the NOC form to address energy storage, site control, and termination. As for energy storage, it can qualify as a QF so long as it complies with PURPA, including applicable fuel limitations. As such, the revised NOC form provides the flexibility for developers to utilize energy storage in a number of ways and requires the developer to provide key operating parameters such as discharge duration and whether DESC will instruct the dispatch of such storage system. The revisions related to site control simply reflect the concepts explained by FERC in its recent order number 872, which relate to requirements such as permits and zoning. Finally, DESC included additional protections in the event the NOC form is terminated to discourage speculative projects. As for the PPA and Standard Offer, these documents represent form offerings for QFs. Pursuant to Act 62, the Standard Offer is available to QFs not exceeding 2 megawatts, while the PPA is available to QFs not eligible for the Standard Offer. Although the Standard Offer is only available to projects not exceeding 2 megawatts, it can be challenging to design a document that is just as appropriate for a 100 kW project as it would be for a 2 MW project. As such, DESC has incorporated many of the consumer protections and contractual obligations from the PPA in the standard offer. And DESC's experience indicates that both of these documents largely address the challenges associated with ensuring these form documents work for a wide variety of projects. As such, DESC is proposing only minor changes to each form contract in this docket. These changes include certain items that were changed to align with DESC's parent company, as well as additional consumer protection measures. In conclusion, the changes proposed in this docket to the NOC form, Form PPA, and standard offer are consistent with the requirements of Act Number 62, provide necessary customer protections, and offer mutually reasonable terms to QFs. I thank the Commission for its time, and this concludes the summary of my direct testimony.
Thank you very much, Mr. Folsom. Did you also prepare and cause to be pre-filed in this case, 12 pages of rebuttal testimony?
Yes, I did.
Are there any corrections or changes to be made to the rebuttal testimony?
No, there are no corrections or changes.
If I asked you the questions that appear in your rebuttal testimony, would your answers be the same?
Yes, they would.
Mr. Chairman, I move the introduction into the record as if given orally from the stand, the rebuttal testimony of Mr. Folsom.
Mr. Folsom's rebuttal testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Folsom, was there one exhibit attached to your rebuttal testimony consisting of 17 pages?
Yes, that is correct.
Are there any corrections or changes to be made to that exhibit?
No, sir, no corrections or changes.
Mr. Chairman, we would move into the record as the next hearing exhibit, the rebuttal exhibit of Mr. Folsom.
Mr. Folsom's rebuttal exhibit will be marked and entered as hearing exhibit 5.
Thank you very much, Mr. Chairman. Mr. Folsom, have you prepared a summary of your rebuttal testimony?
Yes, I have.
Please deliver that at this time.
In my rebuttal testimony, I respond to witness Levitas' suggested revisions to the Form PPA standard offer and NOC form. Specifically, witness Levitas takes issue with 4 changes in the Form PPA and standard offer. My testimony addresses 3 of the 4 issues, while witness Cassis addresses witness Levitas' testimony regarding ancillary services. First, witness Levitas objects to DESC's removal of cash collateral as an express option for performance assurance under the PPA. Although this change was not made primarily to conform to although this change was made primarily to conform to DESC's parent company, and no currently effective PPA utilizes this option, DESC is willing to leave in this express option, given that parties were always able to negotiate the use of cash collateral, regardless of whether it is expressly mentioned in the PPA. Second, witness Levitas takes issue with DESC's increase in insurance coverage and DESC's ability to request proof of insurance at any time during the term of the PPA. At the outset, maintaining insurance is such a basic aspect of project development that DESC did not anticipate this requirement as being problematic. Likewise, the changes to insurance coverage amounts reflect the basic principle that these QF generators are deploying emerging technologies and building more complex projects, which not only increase the insurable values of those projects, but also introduce safety concerns. As such, DESC believes that its proposed changes to the insurance requirements are necessary to mitigate the risk to DESC's customers and do not burden these developers. Third, witness Levitas states that shortening the window of payment under the surety bond and requiring the surety to waive certain legal defenses is unreasonable, with the latter amounting to a poison pill. Put simply, these were implemented to further protect consumers, and DESC disagrees with the assertions given that DESC's parent company has utilized this form of surety bond for a number of years. As for the NOC form, witness Levitas simply describes the existence of a commitment or binding commitment by the QF as sufficient to lock in rates under the NOC form. However, it is important to remember that PURPA does not require states to implement a NOC form. Rather, this is South Carolina's implementation of the LEO concept that I described in my direct testimony. As such, the appropriate threshold evaluation under a LEO is the level of such QF's commitment. The seriousness of commitment has been described in other states as substantial or unconditional, which evidences an effort to uphold the fundamental LEO principles outlined by the FERC, which are a demonstration of commercial viability and financial commitment by the QF. As for the NOC form itself, witness Levitas only takes issue with 2 of the changes proposed by DESC and recommends 1 additional change. The 2 changes made by DESC to which witness Levitas objects were intended to mirror the recent guidance provided by the FERC in order number 872 related to site control and permit and zoning approvals. As such, DESC clarified these concepts in the NOC form to expressly reflect the concepts within order number 872 and incorporate witness Levitas's suggestions to the extent possible. As for site control, DESC revised the language to make clear that although the seller may not be ready to commence construction, it must take meaningful steps to obtain site control so that it could commence construction if available, or if able, pardon me. As for zoning and permit approvals, DESC revised the specific language in the NOC form to require the QF apply for and pay for all fees associated with local permitting and zoning approvals necessary to commence construction. DESC is confident that this specific provision in the NOC form can be limited to the period up to the commencement of construction, given that the PPA contains adequate related protections for the period after construction has commenced. Finally, witness Levitas requested that DESC modify the timeline by which a QF must execute a PPA. DESC reviewed this request and understands witness Levitas's concern that certain projects, particularly more complex projects, may need longer than 90 days to negotiate a PPA. Therefore, DESC accepted this recommendation and modified the NOC form to reflect that a QF must execute the PPA within the latter of 90 business days after submitting the NOC form or 60 business days after receipt of an executable PPA. Although accepting all of witness Levitas's suggestions without modification would dilute or eliminate several protection measures, and with respect to the NOC form would be a serious departure from the FERC's precedent and best practices in other states, DESC has attempted to compromise in good faith wherever possible. I thank the Commission for its time, and this concludes the summary of my rebuttal testimony.
Thank you very much, Mr. Folsom. Mr. Chairman, Mr. Folsom is available for questions from the parties or from the commissioners.
All right, Johnson Development Associates.
Yeah, Mr. Chairman, Court Walsh for Johnson Development, no questions.
Carolina Clean Energy Business Association.
Yes, Mr. Chairman, John Burns for CCBA.
All
I
right.
have some questions for Mr. Folsom.
All right, sir, you may proceed.
Thank you. Mr. Folsom, in your direct and rebuttal testimony, you primarily focus, first of all, let me check, make sure you can hear me okay.
Yes, I can hear you just fine. Thank you.
Okay, great. I hear you too. So, in your direct and rebuttal testimony, you primarily focus on presenting the changes to the documents sought by Dominion in this docket. Is that right?
That's correct.
And before, I think you covered this in your summary, so I appreciate that. You have agreed in your rebuttal testimony to return the option of cash collateral to the PPA. Is that right?
That is correct.
As a form of performance assurance?
Yes.
And you've also agreed to the language in Section 8, Sub 2 of the NOC form that Mr. Levitas had proposed related to the time for execution of the PPA. Is that right?
That is correct. We've accepted that language and it's already included in the document.
And that when you say the document, I just want to clarify for the record. So when we're writing briefs in 6 months or whenever we're writing them, that you're referring to the exhibit attached to your rebuttal testimony. Is that right?
That is correct. Thank you for the clarification.
No, that's fine. Thank you. Are there any other provisions proposed by Mr. Levitas in his direct or rebuttal that you on behalf of Dominion, South Carolina, are prepared to accept?
I don't think that we were prepared to accept his proposed revisions as written, but I do think we've offered a couple of compromises that are worthy of review and that we feel like should be acceptable.
But to date, we haven't reached any conclusions on those possible compromises. Is that right?
That is exactly right.
Okay, thank you. At the conclusion of your rebuttal testimony, you contend that, let me pull it up for you. It's page 11 of the document. And I'm going to share my screen as soon as I get it pulled up, okay?
Sure.
John, is that page 11 of his rebuttal testimony?
Yes, sir. Mr. Folsom, I'm showing you a page of your rebuttal testimony, and I believe it is page 11 of 29, lines 16 through 18. You state, could you read starting with the word however? I'll read it to you. It'll be quicker that way.
Mr. Burns,
Yes.
I don't believe this is Mr. Folsom's testimony.
This is your document, sir. The rebuttal testimony of
Okay.
John E. Folsom Jr.
Okay, continue.
All right. Mr. Folsom, you testified in your rebuttal that accepting all of witness Levitus's changes without compromise or modification would dilute or eliminate several consumer protection measures and industry best practices to the detriment of DESC's customers. Is that right?
That's correct.
It's true, though, isn't it, Mr. Folsom, that Mr. Levitus is not advocating for changes to the existing DESC, PPA, or NOC. It's actually DESC that is seeking those changes, correct?
That is correct.
So let's look at a few of the areas where you and Mr. Levitus, or DESC and Mr. Levitus, disagree. The form PPA was attached to your testimony as your direct testimony as exhibit JEF2. Is that right?
Yes, sir.
All right. I'm going to pull that up if you don't mind. I'll just keep sharing because I've got it here already. And for the convenience of those trying to follow along, it's page 180 of that very large document is the insurance requirements attached to the form PPA amendment that you proposed, correct?
That is correct.
And am I correct that you attached both a clean and a red line copy of these documents?
Yes, sir, we did.
So are we looking at the red line of the insurance requirements attachment D to the form PPA?
Yes, this is the red line.
Great. The first change is in this paragraph 1, changing the time of delivery of a certificate of insurance from a deadline of at least 15 calendar days prior to the start of any work at the facility to within 20 days of buyer's request. Is that right?
That is right. That is the change that is outlined here on the page.
All right. There have not been any proposed facilities since the adoption of the last version of this form that have failed to deliver a certificate of insurance within 15 days of commencement of work, have there?
That is correct. There have not been any facilities that did not meet that requirement.
And the reason given for this change, and I can direct you to your direct testimony if you'd like, but if you'll agree with me, it'll be shorter, but you let me know. The only reason you've given for this change is to conform with Dominion Energy's requirements for insurance. Is that right?
That is correct. And I will go ahead and elaborate briefly because this is going to be a common theme among several of the issues we'll talk about. We have made changes, rightfully so, to conform with the risk management requirements of Dominion Energy in several areas. This particular one here, I don't think we thought it would be a dramatic change simply because, you know, the provision that was there previously is kind of a minimum performance requirement of the seller to provide a certificate of insurance no later than 15 days prior to the commencement of construction. Whereas all along our PPAs have required that the insurance be carried for the full term of the agreement, which starts at the effective date. And we've had the ability to request a certificate of insurance with 10 days notice in section 9.1. So this seemed like a fairly minor change relative to the structure of the PPA from our perspective.
But no proposed QF has ever violated this section in your recollection?
I'm not aware of any QF that has failed to meet this.
All right. You've also proposed to increase insurance coverage requirements further down in this document, correct?
That's correct.
When did the merger of Dominion and its predecessor here in South Carolina occur?
I believe we actually changed our corporate name and gave notice to all the folks we do business with in sometime around April of 2019.
Okay. All right, thank you. Let's look at the policy limits then. In paragraph 2 of the same exhibit that we were just talking about, you have set the general liability from a level of 1 million to 2 million. Is that right?
That is correct.
And $4 million aggregate, correct?
Yes, sir.
All right. Then in the employer's liability in paragraph 4, you've gone from 1 million employer's liability to 2 million each accident for bodily injury, or 2 million for each employee for bodily injury by disease, correct?
That is correct.
All right. And then environmental impairment insurance limits has been raised from 1 million to 2 million per occurrence, right?
Yes, sir.
Turning to the next page, there's another comprehensive automobile policy is required for at least $2 million per occurrence, correct?
Correct.
Are these increases in the form, you've asked for these increases in the form, even though Dominion has not had any insurance claims exceeding coverages at any QFs in its territory since the enactment of the last PPA, of the adoption of the last PPA?
That is correct. We have requested these increases in the various types of coverage, and it is a true statement that we're not aware of any insurance claims that would have exceeded the prior limits.
Okay.
However,
and go ahead.
insurance is one of those things that the best case scenario is you buy it, you pay for it, and you never have to use it. So
That's especially true when it's a best case scenario when someone else is paying for it, right?
well, insurance is appropriate, and it's bought when needed and paid for by the appropriate parties.
The reason for the changes, though, stated in your direct testimony on page 23, lines 3 through 5, is to conform with the corporate parents' policies, correct?
That is correct. The prior insurance requirements that had been in the PPA were somewhat stale. They had been in place, at least to my knowledge, since 2015 or so. Those were SCANA developed and based insurance requirements. And so what we did here, now that we're fully integrated with Dominion, was, since we're in the process specified in Act 62 of every 2 years, kind of reviewing everything we're doing, avoided cost, standard forms, things of that nature, was we forwarded our coverages to the risk management folks in Richmond at Dominion Energy home office. And they did their research, looked at what the standard corporate requirements are, and these are the recommendations that they came back to us for use in these PPAs.
And the prior levels that were approved in the prior PPA less than 2 years ago were approved by the commission and by DESC, correct?
That is correct.
And have you had any loss associated with any of the QS? Well, you've already answered that question, so I'll move on. Have the CDA or the ORS involved in this case indicated that such changes are needed for the protection of consumers in South Carolina?
No, sir. There's been no dialogue with them on this issue.
All right. You also made some, DSC also suggests some changes to the surety bond, correct?
That is correct.
And again, I'm going to thought I heard someone speak up there. Referencing attachment F to your direct testimony, which can be found at page 334 of the PDF. But I think that's part of the composite exhibit hearing exhibit number 4. Is that right, Mr. Folsom?
Would you repeat the last part of what you just said, please?
I think this was the attachment F form of surety bond that I have up on the screen now is a red line and was made up part of exhibit JEF-3 of your direct testimony, correct?
That is correct.
And that was consolidated into hearing exhibit number 4 by the chairman.
Yes, sir.
Bear with me just one moment. All right. Looking at the surety bond, as you can see on the red line, there's a lot of changes to this form, but I think we just want to focus on the 2 that you mentioned in your testimony earlier. In new paragraph number 7, and I'm going to scroll down, ask everybody to bear with me as I get there. New paragraph number 7 seeks to require payment by the surety within 10 calendar days of demand by DESC. Is that right?
That is correct.
In the prior form, and I'm going to I hope we don't have to go back and look at the red line up, a couple pages before. In the prior form, it was required within 15 days of demand, right?
That is correct. The previous SCANA form of surety bond did have a 15-day period.
Okay. And the reason for that change, again, is compliance with Dominion's corporate practices, right?
That's correct. As you pointed out, there's a lot of edits here, and that's essentially because this is a new form. It's not the old SCANA form anymore. And this is the form that was recommended by our risk management folks as what was needed and necessary to protect our customers and provide an adequate bond.
You aren't aware of any circumstances where a surety failed to pay for a loss on a QF in the DESC territory within 15 days of demand, are you?
No, sir, I don't have any examples of that.
In fact, there haven't been any claims on any surety bonds since the adoption of that original surety form 2 years ago.
None that I'm aware of.
All right. There's another change that you recommend on this form on paragraph 6, the preceding page. And I think this one is a bit more, I think that's been a subject of a bit more discussion, Mr. Folsom, than the last one. It would require a surety to abandon, and it's in here on the second page, in the second line of paragraph 6, any defense, reduction, or set-off in advance upon signing of the surety bond. Is that correct?
Yes, sir.
Are you familiar with the difference between a letter of credit and a surety bond, Mr. Folsom?
Generally, yes.
A letter of credit is payable on demand with no defense, generally, correct?
That's correct.
But a surety bond typically reserves defenses and rights for the surety in the event of a wrongful claim on the bond, correct?
I have seen that in other bonds, yes.
Okay. And your proposed form eliminates that distinction, doesn't it?
It does.
And the only grounds given for that change, again, in your direct testimony, are to comply with Dominion's corporate policies.
Well, it's to comply, but it's also to agree and utilize the risk management measures that we have put in place, that our risk management folks have developed, for the sole purpose of protecting our interests and the interest of our customers.
Since the approval of the original surety bond form, have there been any losses against which DESC has sought payment by a surety where the surety refused to pay?
None that I'm aware of.
All right. And are these, I think you testified that this term is reflected in other Dominion surety bond documents?
That's correct.
In other territories of Dominion?
That's correct.
Is that right?
Okay. Yes.
Has any customer of Dominion ever successfully secured a surety bond using the language in this form?
I've been informed that this form is routinely used to secure a surety bond.
Are you aware of any instance within your personal knowledge of any customer successfully securing a surety bond using this form?
I don't have a specific example. I just relied on the information provided to me by the risk management folks in Richmond.
Do you dispute in general that Act 62 requires that the terms of your DESCs and all utilities form PPAs be commercially reasonable?
I don't disagree with that, but I think if you look in Act 62, that standard is applied to multiple participants in the process.
Well, let's do that. Let's look at CCBA Cross Exhibit number 1, which is previously introduced and identified as Title 58, Chapter 41 of the South Carolina Code of Laws. And we're looking specifically at Section 58-41-20. Do you see that?
Yes, sir, I do.
Is that blown up big enough for you to see, sir?
Yes, I can see it just fine.
All right, I'm going to enlarge it just for the chairman because I know he likes 200% on these, so I did that. Looking at paragraph B of that section, it does state, doesn't it, that in implementing this chapter, the commission shall treat small power producers on a fair and equal footing with electrical utility-owned resources by ensuring that, and then number 2, power purchase agreements, including terms and conditions, are commercially reasonable and consistent with regulations and orders promulgated by FERC implementing PURPA. Correct?
Yes, that's what it says.
So the PPA terms and conditions need to be commercially reasonable.
That is correct.
All right. Among the forms that DESC seeks to change is the notice of commitment form. And you've provided a red line of that as well. And I'm going to refer, for the purposes of this questioning, to the rebuttal test, the exhibit attached to the rebuttal testimony. Would that be the one that represents the most up-to-date after the revisions to accommodate Mr. Levitus's concerns?
Yes, sir.
Thank you. I want to direct your attention on page 9 or page 21 of the PDF, page 9 of the attachment. The notice of commitment to sell form. Do you see that on the screen in front of you?
Yes, sir. I do see it.
Was that the one that was attached as revised JEF1 to your rebuttal testimony?
Yes, sir.
Okay, good. I just want to make sure the record's clear that we're both talking about the same document. See paragraph 4, sub 3 of this document, and I'm going to scan down and make everyone dizzy again. By execution and submittal of this notice of commitment, seller certifies as follows. And number 3, which is a new paragraph, correct?
Yes, sir.
States, seller has taken meaningful steps to obtain site control of the project site adequate to commence construction of the facility. Did I read that correctly?
You did read it correctly.
A QF or a developer doesn't need to start construction to create a legal enforceable obligation under PURPA, does he?
No, that is not required.
It just needs to unequivocally commit itself to sell DESC its electrical output at an agreed upon price and terms, correct?
Well, it has to make a substantial commitment to do the things that you just said.
Right. And in South Carolina, the commission has adopted the NOC form as the indicator of that commitment, correct?
That is correct. That was adopted in the previous proceeding.
Do you agree that the current NOC form before these proposed revisions required that the seller have control of the project site without requiring it to be, quote, ready for commencement of construction?
That is correct. This language has changed since the last form.
Are you aware of any proposed QF facility in the DESC territory on which a seller has obtained control of the site, signed an NOC, and then failed to follow through with construction?
I do not have an example of that scenario.
You'd agree, don't you, that there would be costs incurred in reaching the status of being adequate to commence construction, wouldn't you?
Well, there may be costs incurred, but that doesn't mean it's a bad thing.
Okay.
I mean, essentially part of the reason that we felt the need to make some adjustments to this form is some additional guidance and orders that were issued by the Federal Energy Regulatory Commission on these matters, Order 872. That was a big topic of discussion in that order as to what is adequate and what is necessary to establish a LEO for a QF. And that's where it became even more clear that a QF must demonstrate commercial viability and financial commitment in order to do so. And the FERC went on to provide examples of viable parameters that a state could use and could enforce to be able to demonstrate that level of commitment.
Thank you. I'll have a couple of follow-ups on that, but I want to look at the next change that you suggest, and what's now new paragraph 4, the following paragraph, paragraph 4, sub 4. The documents attached here too as Exhibit B establish that seller has secured or has submitted all applications and filing fees necessary to secure all local permitting and zoning approvals for the project site necessary to commence construction of the facility. Did I read that correctly from the document?
Yes, you did.
You are aware, sir, that many construction permits required to commence construction may not be issued by a locality until the very eve of construction, don't you? Is that correct? Would you agree with that?
Would you repeat that for me, please?
Are you aware that many of the construction permits required to commence construction in a given locality may not be issued until the very eve of construction?
Well, I will be the first to admit that I don't work on the construction side of these facilities. So I don't know that I can say that I'm 100% aware of that, but I will add the clarification that this provision does not require the issuance of those permits and those zoning permissions. It only requires that there's a demonstration that the applications and fees have been processed.
And a schedule in a given locality which requires applications for permits to be scheduled near the end of a pre-construction process wouldn't be instructive as to a developer's seriousness of purpose or commitment, would it?
Well, would you mind repeating that for me? I didn't quite get the last part of that. I apologize.
Let me try. Let me warm up to that one. You said in your rebuttal on page 11 of line 20 of your rebuttal that you said that Mr. Levitas's proposed changes would, quote, establish an LEO by simply showing a commitment without examining the seriousness of such commitment. Was that your testimony?
Yes, sir.
But the willingness of a locality to issue a permit is not an indication of the seriousness of commitment of a developer, is it?
Well, again, I think you just said issue a permit.
There's two questions here. The first one is the issuance of a permit is not an indication of the seriousness of commitment of the developer, is it?
To be honest with you, I'm not quite sure how that's relevant to what we're looking at here.
All right.
And I say that because we're not requiring any issuance at this point in time.
Well, would you agree with me that the issuance itself has no indication of the commitment and the seriousness of the commitment of the developer?
I will agree that the way we have worded this term, which we modeled very closely for language right out of FERC Order 872, does not envision the actual issuance of a permit or a zoning approval establishing this level of commitment.
And you just earlier testified that you're not familiar with the construction side of these projects.
Not overly familiar. No, that's not what I do. I do.
And you wouldn't know
PPAs.
And you wouldn't know what schedule is required by different localities for the application and payment for application fees of various permits and zoning regulations, would you?
No, I don't claim to be intimately familiar with those issues in different areas, but I will say we in pulling these terms together very much hung our hat on the fact that the FERC had defined these parameters as valid and useful ways of establishing and verifying the level of commitment necessary. So, you know, we're kind of putting our faith in the FERC that these particular parameters are reasonable and good ways to establish this.
Would you agree that it is possible that a developer may in fact not be able to comply with this requirement, that all permits and approvals be applied for at the time that the PPA and the NOC need to be executed?
Well, again, our assumption would be that if the FERC put this out there as a viable way to do it, that it's a reasonable way to establish the level of commitment.
I don't know if your mom told me what my mom often told me, is that just because you can doesn't mean you must, right? Do you recall that?
I've heard a mantra similar to that a few times in my life.
All right. Finally, the proposed standard form PPA that you've proposed defines energy as including ancillary services such as reactive power and voltage control. Are you familiar with that?
I am familiar with that.
You said in your introduction that testimony was really the testimony of Mr. Cassis and not yourself?
That's correct. He addressed the ancillary services issues in his testimony.
Okay. Did you differ from did you have a chance to hear his testimony or read it?
Yes.
Okay. Doesn't the inclusion of ancillary services in the definition of energy under the PPA require the sale of those services at no additional cost beyond the rate of avoided energy?
That is what the language says today. You're correct.
Would you agree with witness Levitas that provision would not be fair and reasonable if the value of those services is not accounted for in the calculation of the avoided cost rate?
I do hear your question, and I think I can add a clarification that may move this along if you are okay with that.
Sure.
You know, we've discussed this particular issue internally, and, you know, since the last round of discussions on it, we have determined that we are willing to look at making adjustments to the definition of energy in the PPAs and change some of this language as you guys have referred to it. But it, you know, just has to be understood that in any situation for a QF project to be able to be compensated for any ancillary services, there has to be a very clear demonstration that by virtue of operation of that facility, DESC is avoiding the provision of those services from other sources.
Would you agree then that it would be better if you're going to strike that? I'll answer this last question this way, Mr. Folsom. I'll ask it this way. Section 58-41-20B of the South Carolina Code requires that avoided costs fairly account for all costs avoided, including ancillary services, correct?
Yes, sir.
Okay, so would you agree that we need to work out some way to fairly account for those ancillary services in the definition and calculation of avoided costs?
I would agree that the definition needs to be improved. And as I said a moment ago, for there to be any payment for ancillary services, there would have to be a very clearly studied and well-defined demonstration that a QF is providing such services.
Great. I appreciate your testimony, Mr. Folsom. I have no further questions at this time. Thank you, Mr. Chairman.
Thank you.
Pine Gate Renewables LLC.
No questions, Mr. Chairman. Thank you.
South Carolina Coastal Conservation League, Southern Alliance for Clean Energy.
No questions, Mr. Chairman. Thank you.
South Carolina Department of Consumer Affairs.
No questions, Mr. Chairman. Thank you.
Office of Regulatory Staff.
This is Chris Huber, Mr. Chairman. We have no questions for this witness. Thank you.
All right, sir. Commissioner questions. Commissioner Powers.
Good afternoon, Mr. Folsom.
Good afternoon, sir.
As someone who's been a trial lawyer for the last 40 plus years, when I see a requirement for $2 million in automobile insurance, I'd have to say if I was still a trial lawyer, that's a lawyer's dream for such an extreme amount of insurance to be available. But we also, as you know, are involved in moving vans, trucking, all sorts of different things. And rarely can I say I've ever seen that much coverage. What makes $2 million reasonable and necessary? What sort of travel would these QFs be doing, or what sort of acts that they could perform that would require that much coverage?
Well, thank you for your question, Commissioner Powers, and I certainly understand your thought process there. I will say, and I may have said this earlier, that I don't think I went into the level of detail, so I'll give a little more background. The way that our risk management group developed these levels of coverage that they deem necessary for these types of agreements was they worked closely with their insurance broker. They knew the type of contract that we were working with. They worked with their broker to analyze the market, which included thinking about social inflation and evaluating the levels of cost associated with insurance claims, be it settlements paid, be it hospital bills, be it any other sort of cost that would cause claims to build up. And this is what they arrived at, surveying the market and putting best practices in place. So I guess I gave a much longer answer than I should have. I probably should have just said, I don't really know the answer to being able to give you specific examples of what would lead to that level of coverage. But we do have confidence that our risk management folks are good at their jobs and talented, and did all the background work they needed to be able to recommend these levels of coverage,
Well,
including the automotive.
I would understand you having that type of coverage or more for your drivers of your trucks and different things where it would put you in a situation of direct liability. But such an increase to me seems that it would discourage investment and when it would discourage QFs, particularly with all the other insurance requirements, which I don't think I need to go into, but I mean, that's an increase of 100%. I think one of the TV lawyers would say that's a lot of money.
Yeah, and I can say with certainty the intent of any of these changes would never be to discourage investment or anything along those lines. Our intent here is to make sure we put adequate and reasonable coverages in place to provide the protections that our customers should always have in these types of situations.
And I think that's my point, is the word reasonable. And I question that and would hope that maybe some point your company could look at that.
Yes, sir. Thank you.
Thank you.
Commissioner Caston.
along those lines, Mr. Folsom, I noticed, I guess at least twice, maybe three times, these suggested modifications were being made to come more in line with Dominion Corporate. And I certainly appreciate and understand the desire to have more agreements in line and with corporate. But I guess the question I'd have or ask is, are these suggested changes needed and in the best interest of customers? I'm not sure I necessarily heard that so much as, well, that's what corporate wants. Not that there's anything wrong with that necessarily, but I didn't hear that part answered.
Well, to address your question, and thank you for your question, Commissioner Caston, maybe I didn't phrase it as well as I should have when I've mentioned this issue, you know, earlier in my testimony here. But the intent all along was to send these insurance requirements to our current risk management review group and have them take a fresh look at it from the perspective of what they know in the current insurance markets and what they know about the type of business we're doing, and to have them provide us with recommendations as to what they feel we would need to have in place to provide adequate protections for our customers in these types of agreements. And so what we've done here is we've received that information from our sophisticated risk management group, and we've put those before the commission for consideration.
I understand, but I wasn't specifically talking about insurance, although I think that's good. I was talking about, you know, changing from 15 days to 10 days, changing, you know, the various, again, I'm not saying the changes are good or bad. I just didn't hear in your response to the changes that, you know, Mr. Burns actually asked you about, and I think witness Levitas had questions on. I just didn't hear anything that seemed to describe how that was in the best interest of the customers or the potential QFs, whatever. But perhaps you can think more about that and someone later can answer. Something I did want to ask you, and I thought I heard you say, relative to, I think, one of Mr. Burns' questions on that item 4 by execution, submittal of the notice of commitment. He's talking about the item 3I and 4I that were added. If I understood you correctly, that is directly from the July 28th, 2021 FERC order, correct?
That is correct. We pulled language directly from and modeled it after that language you're referring to in Order 872. Now the second, I want to be clear, the second provision, the provision that relates to the permits and zoning requirements, we actually softened that a little bit because the language that was in FERC Order 872 said requiring all permits and zoning requirements, and we as what we deem to be kind of a reasonable compromise, cut that back to where we only require zoning and permits that's necessary to commence construction.
Yes, sir. I believe I read that also.
Yeah.
Okay, no further questions. Thank you.
Thank you.
Any more questions from commissioners? Any redirect?
Mr. Chairman, I do have just one little subject on redirect.
All right.
Mr. Folsom, you were asked some questions about requiring $2 million of in insurance. Do you recall those questions?
Yes, I think that was specifically focused on the automotive insurance.
In terms of looking at the cost of the solar generators and their construction costs, would a 70 megawatt solar generator cost more than $5 million to construct?
Absolutely.
Would it cost more than 25 million to construct?
Yes, sir. You're probably looking at something closer to 80 or 90 million.
Thank you very much. Those are all the questions I have.
All right, if there's nothing else for this witness can step down. Mr. Folsom, thank you for your testimony. Please step down. You are excused.
Thank you, Mr.
Thank you
Chairman.
very much, Mr. Chairman.
All right, folks, we got some housekeeping that we need to do. My understanding is that witness Cersei is unavailable Tuesday between 2 and 4. Is that correct, Attorney Mixon?
Yes, Mr. Chairman, that's correct.
All right. Do you or any of the parties object to him testifying first after the applicant finishes their case?
No, Mr. Chairman, I don't, we would have any objection to that.
Okay, that would put him testifying after Mr. Rooks on Monday.
I think that should be fine.
All right. Do any of the parties have an objection to taking Mr. Cersei out of order?
None from DESC, Mr. Chairman.
And hearing
No, sir, no objections from CC.
All right.
No objection for ORS.
All
None
right.
from DCA.
No objection from Pine Gate, Mr. Chairman.
All right. Next item to address on Monday, we will reconvene at 9 a.m. And we will adjourn for the day at 4 p.m. on Monday. Other than that, the schedule for next week remains the same. And if you would, please discuss the issue of ORS stipulating to their witnesses' testimony and be prepared to discuss on Monday morning. Is there anything else?
Nothing from DESC, Your Honor.
No,
Oh.
sir.
All right. Thank you, folks, for trying to adhere to our schedule. We appreciate that. We are in recess until Monday at 9 a.m.
Thank you very much.